Hi, my name is Hrle. I'm attorney of law from Belgrade, Serbia. Some of you may already know me. I gave a presentation last year on Serbian criminal procedure code. Today, I will speak about three topics, some of which had a really crucial impact on advocacy in general in Serbia, and some of which should determine the future course in which all advocates will act in the future. Okay, this presentation will have three topics as stated. The first one will be the explanation and of the lawyers' strike in Serbia. The second topic will be the creation of the new networks in the Western Balkans. And the third topic will be the current issues in application of the Serbian Criminal Procedure Code. As to the first topic, the lawyers' strike, as we like to call it, but we try to avoid the word strike because it's not legally, it is not the most accurate one, but for the sake of clarity, I will use the word strike. Currently, in Serbia, all lawyers are on strike. This means that they do not attend hearings in court of all instances, excluding the hearings, the appeals hearings, and the hearings that take place regarding the protection of minors. All civil proceedings are also stayed, they're not taking place, and lawyers are refrained from taking action, any kind of action with respect to court. Why this happened, and what is the reason for the lawyers' strike? Well, the initial reason for the lawyers' strike was unreasonably and unjustifiably increased tax rates. Last year, this began by the introduction of the new tax policy of the newly elected government. This new policy also had impact on advocates. In some cases, the tax rates went up to 300%. So you can imagine what this means for a lawyer, especially for younger lawyers who started their practice recently, and this high tax rates really have impact on their performance. The second reason, which subsequently became the principal reason, was the enactment or the introduction of the new law on public notaries. And basically, a lot of work of civil lawyers that related to drafting of real estate contracts has been, with this new legislation of public notaries, transferred to public notaries. And the vast majority of lawyers in Serbia was left without their principal income, which was related to drafting of real estate contracts, which was now within the competences of the public notaries. If you link this, meaning this in conjunction with the unreasonably high tax rates, led to decision of the regional bars and the Serbian bar to begin the lawyers' strike. And currently, as we speak, all lawyers in Serbia are still on strike. However, the Serbian advocacy took a proactive role in and started negotiations with the Ministry of Justice, which was the key actor in this new law on public notaries, and with the Ministry of Finance, who was responsible for the tax rates. Currently, negotiations are ongoing, but there is a strong possibility that the authorities will comply with the demands of the advocates and that they will lower the tax rates and the tax rates will be probably not higher than they were in last year, most probably. And as regarding the public notaries, the work of the public notaries regarding the drafting of real estate contracts will be returned to lawyers. So basically, we can say that there is a strong possibility that authorities will hear and will adopt all, well, not all, but most of the demands of the advocates in Serbia. In this respect, the advocates in Serbia, the Serbian advocates also addressed all relevant international institutions and international bars and raised their and drew their attention to the existing problem of the Serbian advocacy. Also, we addressed other international stakeholders and emphasized the importance of the demands of the advocates, especially taking into account that Serbia is in the negotiation procedure within the EU, meaning that chapters 23 and 24, which relate to a proper function of the judiciary and the rule of law, have to be taken into account, having in mind the lawyers' strike in Serbia. So, having said all this, we hope that these negotiations will end soon and that the ministry will hear and adopt all of the relevant demands of the Serbian advocates. Regarding the second topic, the second topic is related to the establishment of two regional networks. The first regional network was established by the American Bar Association, more accurately, their Rule of Law initiative, which created this so-called Balkans Regional Rule of Law Network. This network has one of their main principles is to help establishing effective defense bars throughout the region. In this respect, initial conference was held in Skopje in May, and all of the principal ideas of this network was brought to attention to the potential members, and some of the working groups were created to this end. I will mention only a few. Criminal Law Reform Working Group, which I'm a member of, Civil Society Group, Legal Aid Group, and Bar Capacity Working Group. It's only some of the working groups that were formed in Macedonia in May. Regarding the work that is to be done within these groups, some of the work of the criminal law reform group related to problems regarding the structure and the content of the criminal law provisions of the Western Balkan states, especially the equality of arms, access to state evidence, rules of evidence, harmonization with the international standards, and incorrect implementation of the trial in absence. Impartiality of judges toward prosecutors and lawyers, problems regarding defense investigation, and misuse of the pretrial detention during criminal procedure. These were only a few of the topics, but probably the most relevant ones that will be covered by the criminal law reform working group. This network brought together advocates and civil society lawyers from Bosnia and Herzegovina, Serbia, Macedonia, Kosovo, and Albania. The second network, well, actually, this is still in the pipeline, but probably this will be some sort of a network, or maybe network within. Yes, probably this will be a part. This relates to the Fair Trials International and the project they had in mind regarding the Western Balkan states. To this end, a meeting in Podgorica was convened by the Fair Trials, and some of the topics were raised in order to clarify whether there is a need for the proper training of EU roadmap directives. To this end, the idea of this Podgorica meeting was for the participants to understand the regional fair trial right concerns, to see to which extent are the EU roadmap directive relevant within the Balkans, Western Balkan states, to identify the key drivers of criminal justice reform in each country, and to assess whether it would be feasible to use the facilities of legal expert advisory panel of Fair Finance International in order to raise the attention of the relevant stakeholders in the Western Balkan states to the roadmap directives, the ones that were adopted and the ones that will be adopted, and to use the EU negotiation procedure in some of the Western Balkan states, in order to address the importance of the criminal defense rights in the candidate countries. Well, I would have to say that this, in my view, this was a very, very good idea that was brought by Fair Trials International, and some of the conclusions that were made in Podgorica were, at least to me, very, very, very productive, and I hope that this EU dimension will really have an impact on the relevant stakeholders in all of the countries. In this case, I speak only regarding to Serbia. I really hope that the use of the accession procedure will be a very fruitful way for some countries to draw the attention to the rights of defendants that were especially to the roadmap directives. Well, this network will probably be linked to the, as I stated, to the legal expert advisory panel, and we will use their facilities, attend trainings and conferences of LEAP network, which will enable us to be integrated more closely to their network. And of course, this will have also a huge impact to all lawyers that will attend these meetings, because as stated, this network has a really clear EU dimension, which is a very, very good. It is a very good motive for the relevant stakeholders in candidate countries when you say that when you're trying to make changes of the law, it is very good to say, okay, we are changing this because we are in the EU accession procedure, and if we change this, we will be in line, for example, with the EU directive on the access to a lawyer. I'm just trying to simplify things because in candidate countries, this really works. It works when you say that you are doing something for the benefit of the EU accession, and that something is good because it will kind of boost the EU accession. It's a good argument within the relevant stakeholders. So this approach of the Fair Trials International and the use of the EU accession procedure to raise the defense rights in the region is a very good idea. Okay, the third topic is related to the problems in application of the new Serbian Criminal Procedure Code. I know this is a really huge area, and I already had several occasions in which I drew the attention to the problems in which we lawyers encounter almost every day regarding the application of the new Serbian Criminal Procedure Code. And I know that I don't have enough time, so I will try to keep this short. But I just have to mention a couple of things that are really important for the proper application of the new code. Last year, my presentation was related to what was on paper. Some of the solutions that were made in the new code were good, and if you look at it, this code looks really good. However, there are certain amendments that need to be made in order to have a proper equality of arms. Although the new code proclaims that is one of the basic functions is to raise the level of rights of defense and to adhere to the principle of equality of arms, this is not the case. I will not go into the details too much, but I will only address issue that is constantly encountering by the defense lawyers in cases in Serbia. One of the crucial areas and one of the crucial parts in which reforms are needed, even though this is a new code, is the area of the disclosure. Although the prosecution is now is obliged to enable the defendant and his defense counsel to examine the objects and which will be used as evidence, the prosecution often misuses this obligation when it comes to exculpatory evidence. Why is this the case? Because probably there aren't any good mechanisms that could prevent this that should have been included in the code. On the other hand, the defense has its own obligation as it is obliged to disclose all evidence all objects that will be used as evidence by the end of the investigation. This is a really huge problem because in this way the defense is prejudicing its own case, and it has to prove that it's proving that it's innocent. Why? Because at the end of the investigative phase, the defense is not familiar with the case of the prosecution because the indictment is not lifted yet. So we are in this is a paradox because the defense has to submit evidence has to disclose all evidence to the prosecution, even though it's not familiar with the prosecution case because the indictment is not lifted yet. So the defense is prejudicing its own case and is in a way shifting the burden of proof to the accused because the defense now has to prove that the accused is not guilty. And this is also not in line with the EU proposed directive on presumption of innocence. I know this is a huge topic and I have really had to address it, but this is an important issue for us because it is in a way illogical for the defense to disclose all evidence to the prosecution at this early stage in the investigative phase. It should be logically before or at the end of the prosecution case and before the commencement of the defense case, when the defense should be obliged to disclose all evidence to the prosecution. Okay, I will not take you too much time anymore. Thank you, Alexis. Thank you, Susan, for the inclusion in this really interesting new project. So I'm at your disposal and really happy to continue working with you guys. Bye.